The next matter to come before us this morning is Seth Cromer et al. Versus Children's Hospital et al. Both sides will have 15 minutes to argue. The appellant, cross appellee, may reserve up to 5 minutes for rebuttal. We've read the briefs, so they receive anyone.
Thank you, Your Honor. May it please the court, my name is Tom Houlihan. I'm here on behalf of the family of Seth Cromer. I would like to reserve 5 minutes for rebuttal, and I intend to keep my comments relatively brief since we have a limited scope of review here. The matter is on remand, of course, from the Supreme Court just for assignments 2 and 3 from our original brief from back in 2012. That's the manifest weight and motion for new trial issue. In this case, the nurses involved in the case gave Seth Cromer the wrong fluids. There was expert testimony that this was a breach of the standard of care, and there was no rebuttal evidence that was competent and credible under the manifest weight standard to contradict that. Yet the jury found no negligence. That negligence determination was against the manifest weight of the evidence. The evidence put on by the plaintiffs...
I'm sorry, did you say that the jury found negligence?
Found no negligence.
Oh, okay.
Yeah. The manifest weight of the evidence issue is obviously dependent upon what evidence was presented. And the Cromer family put on evidence through their expert, Dr. Parker, that proper and timely fluid resuscitation plus intubation, timely intubation, would have likely saved Seth Cromer. That's 902 of the transcript. There was an initial hour delay before Seth received any fluids because he was not treated at all in that hour period. And then he received the wrong fluids, which further delayed his appropriate fluid resuscitation by another half hour.
But now the hospital is saying that it wasn't necessarily the wrong fluid, it wasn't just the most optimal fluid.
Well, that depends upon who you ask. If you ask the defendants themselves, they say it wasn't the most optimal fluid, et cetera, et cetera, et cetera. But everybody involved in the case recognizes that at the very least that wasn't the best, or wasn't what was ordered for the patient. I could go.
We have to look at both of those when we're looking at weight of the evidence.
Sure, but let's talk about what the expert testimony was, which was that it was not a fluid that would effectively resuscitate the child. I could go into a dissertation on osmolarity. I learned all about it in this case, but the salt content of the fluids that the child received were not sufficient to rehydrate the child because the water would be pulled out of the blood vessels and blood tissue because of the wrong fluids. Now, the hospital did put on some evidence delay in intubation was not a breach of the standard of care, but they didn't put on any competent, credible evidence in rebuttal that giving the wrong fluids or the suboptimal fluids met the standard of care. In fact, defense expert, Dr. Kennedy, admitted that administering those fluids was a medical error and fell below the standard of care. Now, we presented this in our brief, and in rebuttal, the hospital pointed to a number of items that they claim rebutted this evidence. But if you look at what they cite to, it's almost exclusively the defendant's testimony themselves. Nurse Strickland, who gave the wrong fluids, I'm going to continue using that parlance because that's the way it was used in the trial court, said, well, I didn't breach the standard of care when I did that, and that's understandable. Every defendant's going to defend themselves. Her superiors, Dr. Luxmore, Dr. Windorf, also said she didn't breach the standard of care. It wasn't the optimal fluids, it wasn't what I ordered, but she didn't breach the standard of care by giving them.
So you're saying no disinterested expert said that they met the standard of care?
Well, we'll get to that in just a second,
Okay,
but the majority of the brief is citing to folks who were defendants in the action. And there's authority that we cited in our brief, State versus Freeman, Chris versus Scioto, that says those sorts of self-serving statements are not competent, credible evidence in the manifest weight analysis. Every defendant's going to defend themselves. If you allow a self-serving defensive statement like that to meet the manifest weight of the evidence, then there's no reason to have a manifest weight of the evidence standard or a civil rule allowing new trial when the manifest weight of the evidence is not met, because every defendant's going to defend themselves. So let's look at the only other piece of evidence that the hospital cited that suggests that Nurse Strickland met the standard of care. And that was a statement from their defense expert, Dr. Kennedy, early in his testimony, where he made a general statement that the nurses met the standard of care. And he did say that early in his testimony. However, in cross-examination, page 1137 of the transcript, he was specifically asked the question about the fluids. And he admitted that administering the wrong fluids was a medical error and fell below the standard of care. So he clarified his initial early testimony, general testimony, with specific answer that agreed with the plaintiff's expert that that act fell below the standard of care. So there is an absence of competent, credible testimony to rebut the fact that giving the wrong fluids was a breach of the standard of care. Therefore, this case is controlled by State Ex Rel. Rogers versus Elbert, which is cited in our brief. When the plaintiff presents evidence and there's no competent evidence to contradict that evidence, a verdict by the trier of fact that is inconsistent is against the manifest weight of the evidence.
But so you're taking the position that, to go back to Judge Carr's inquiry, that the testimony of even the interested parties would not be considered as inconsistent with the evidence that the actions fell below the standard of care.
The statements of the interested parties, the defendants, can be read a couple of ways. The interested parties, I'm finding it here. Nurse Strickland admitted that giving the bag of fluids was, quote, open, careless nursing. That was one of the defendants, but she went on to say, it was careless nursing, but I met the standard of care. Even Dr. Luxmore, one of the defendant doctors, admitted that the D5 half-normal saline, which was not what was ordered, was not the optimal fluid for Seth to receive, but he also said they didn't breach the standard of care. So, in the one respect, there are statements in the record from the defendants themselves that say, no, nobody breached the standard of care here, but that's what one would expect. They did make some admissions, though, that suggest that there were some problems with the fluids they gave.
Right, and whether or not I testify that someone breached the standard of care is my expert opinion as to the legal standard of care, correct? I mean, there's other testimony, is there not other testimony in the record about the effects or non-effects of this particular solution versus other solutions?
That's a different issue. That's a causation issue. There's a lot of talk about whether or not this particular fluid was effective or not for rehydration. Everybody who testified suggested that it was not, at least not the optimal thing to give because the osmolarity was wrong. So if you want to go down the branch of causation, that's a different issue. This is a question of whether or not giving these fluids was a breach of the standard of care. Dr. Parker, the plaintiff's expert, says it was. Dr. Kennedy, one of the defense experts, also said it was. The other folks who talked about standard of care were the defendants, and they all denied that it was. So you have two witnesses talking about Nurse Strickland's standard of care who were not parties. They both agreed that it was a breach of the standard of care. The parties said, no, it wasn't. Okay? So it's been generally recognized in the past that a trier of fact is free to reject testimony, even if that testimony is unrebutted. But if you look at the State versus Rogers and Elbert case, this court at page 11, paragraph 12, found that that's no longer the case under Ohio law after the 2007 Ohio Supreme Court case, which I didn't write down, I don't remember off the top of my head. But the Rogers versus Elbert case says the jury is not free to disregard unrebutted testimony. It must act in accordance with the testimony. So here, evidence was put on by the plaintiff that failing to give appropriate fluids at the appropriate time was breaching the standard of care. The hospital cannot point to competent, credible evidence to rebut, only to the statements of their own parties. So the jury's verdict on negligence was against the manifest weight of the evidence, and a retrial should be granted. And if there are no questions, I'll yield to my opponent. Thank you.
May it please the court. My name is Greg Rossi, and I represent Children's Hospital Medical Center of Akron in this case. The issue before this court is whether this court is willing to overturn a proper jury verdict when that verdict was supported by ample, competent, and credible evidence and testimony and when the trial court did not abuse its discretion in denying plaintiff's motion
What
for
is
new
our
trial.
burden in regard to that? I mean, what is our burden? What's our standard of review? Because all the parties keep referring to competent, credible evidence, but it seems to me like we're doing more than just looking at competent, credible evidence. We're actually weighing the evidence.
Your Honor, I would cite the court to State v. Wilson and C.E. Morse Company v. Foley Construction Company from the
Well, what
Ohio
about the
Supreme Court.
Easley case, where the Supreme Court said we're going to be looking at it the same as we do a criminal case, and we're going to be weighing and looking at persuasive nature of the testimony, not just the competency and the credibility.
Your Honor, I must say I'm not familiar with Ely.
That's okay, that's all right.
but-
It's just when another judge was on this court, that was a huge, big issue that went up to the Ohio Supreme Court. So
But-
that's all right, we'll look at it. I just, I was wondering when I was reading the briefs, I was like, well, look, we have to look at the persuasive nature of it too, and weigh the evidence, not just, is there any evidence there to support it?
But even if you were to do that, Your Honor, in this case, there was plenty of testimony and evidence that this was not a deviation from the standard of care. We presented evidence to the jury that while this was a mistake, Dr. Luxmore ordered normal saline, and Nurse Beth Strickland hung D5 half-normal saline. While there was testimony that that was a mistake, and we acknowledge that, the overwhelming testimony from our side was not something that would rise to the level of a deviation from the standard of care. So even if you were to apply, I think, a different standard, you would arrive at the same conclusion.
Do you agree that that only the interested parties here that have said that it wasn't optimal, but it didn't meet the standard of care?
Dr.
You had an actual expert testify opposite of that?
Dr. Kennedy did acknowledge on cross-examination that he felt it was a departure from standards of care to give the wrong medication. However, on his direct examination, he said he felt that the nurses met the standard of care. So if anything, there was some conflicting testimony that he gave. What he also said at page 1091 of the record was that there was no harm to this child as a result of this. This was not the optimum fluid for him.
Well, doesn't that go to proximate cause then?
But there's no causation here, Your Honor. Even their own expert agreed that giving this medication caused this child no harm. And there was plenty of testimony. Dr. Luxmore testified that the nurse met the standard of care. This was not a departure. Dr. Wendorf testified this was not a departure from standard of care. And perhaps most importantly, this nurse testified, Nurse Beth Strickland, in front of the jury. She explained why she did it, why she made the mistake. She acknowledged it was a mistake, but she did not feel it was a departure from standards of care. And consistent with State versus Wilson, then, the jury viewed the witnesses, observed their demeanor, gestures, and voice inflections, and used these observations in weighing the credibility of the proffered testimony. And when they did that, they determined that this was not a deviation from the standard of care. So, I would say that the standard embraced in State versus Wilson is the one the court should follow. But even if there was a different standard applied by the court, still, there is plenty of testimony in this record to support what the jury did. And there's nothing here. I know he wants to argue State ex rel Rogers. That was a different situation. In that case, that was an Ohio EPA case, and there was no testimony in that case or evidence presented by the property owners to rebut the state's claims. That's a much different scenario than what we have here.
Let me ask you this. In regard to the motion for a new trial, I apologize for taking on.
Sure, that's fine.
It kind of goes all hand in hand.
Sure, it does, you're right.
What, if anything, can we consider from the Ohio Supreme Court? This is a tricky question, so I
Sure.
apologize. And I don't mean to make it tricky, I'm just having to struggle with it. What, if anything, can we take from the Supreme Court saying, okay, Court of Appeals, you got it wrong because there's no prejudice, but 7 of the justices said this was definitely an incorrect jury instruction that was given. So my question is, what, if anything, can we do with the fact that 7 Supreme Court justices in this court has said that that's an incorrect jury instruction? you may not have demonstrated prejudice in regard to the verdict based on the jury instruction, but can we use that improper jury instruction when we're evaluating whether a new trial should be granted and the weight of the evidence? Because the court did say it was incorrect.
Well, what the court did say at the end of its opinion, Your Honor, was the following. Further, in contrast to the manifestly erroneous instruction in Cleveland Electric Illuminating Company and the factually unsupported instruction in Hayward, the foreseeability instruction in this case was drawn from the actual facts presented, but was mere surplusage. Accordingly, the record in this case does not establish that the unneeded jury instruction on foreseeability prejudiced the Cromer's substantial rights, and the appellate court's reversal was not justified. So, yeah, they certainly talked about prejudice, but they also said it was mere surplusage and not an incorrect instruction.
Well, I think earlier on, if you read the opinion closely, you'll see very clearly they say that it is an incorrect instruction.
They also pointed, Your Honor, to the fact that the only manifestation of the jury being misled by the foreseeability instruction, and I would say by any instruction in this case, that was argued and then identified by the court was the interrogatory regarding proximate cause instead of stopping after finding that negligence had not occurred. But what they went on to say was the jury's answers to the negligence and the causation interrogatories, both in favor of the defense, were not inconsistent with one another, nor were they inconsistent with the general verdict. So, and they said earlier in their holding as well that the jury instructions in this case on the whole, when you look at the standard of care, the jury instructions regarding the applicable standard of care as a whole were not misleading. The jury instructions that they argued in their motion for new trial were different procedures and specialists. Those are instructions contained within the court's standard of care instructions. So the Supreme Court has held that those instructions were not misleading.
Well, we can't look at the instructions. I'm not trying to, in regard to whether they were prejudicial per se, but I'm going to ask the appellant's counsel the same thing when he gets up. But are we allowed to consider the impropriety, that they were incorrect? And I understand you don't read the Supreme Court case the same way that maybe I would or somebody else would, but the point is, you're saying that we cannot consider those instructions whatsoever.
I think, Your Honor, what the court is limited to at this point is considering their argument on manifest weight of the evidence and their argument presented to the trial court moving for a new trial. And foreseeability is nowhere in any of that. So no, I don't think the court can consider foreseeability at all. And I think the court's analysis at this point is limited to those two issues. And as it relates to the two issues, so the motion for new trial was manifest weight of the evidence, which we've already talked about. Jury instructions focusing on specialists, which we had two different specialists here, Dr. Luxmore and Dr. Wendorf. So those specialist instructions were appropriate and necessary. And the last instruction that they argued in their motion for new trial was different procedures. They raised a contention regarding Dr. Wendorf's treatment modalities that he put in place, which included a central line, an arterial line, and then intubating the child. Their expert said the order should have been central line, intubation, and arterial line. So she took umbrage with the different procedures and the manner in which they were undertaken. She did acknowledge, however, that many of her peers would have done it the exact same way. So that instruction was appropriate as well. And again, as we said, the Supreme Court has already said that looking at the instructions on standard of care on the whole, they were not misleading. Lastly, their third argument in their motion for new trial was inconsistent interrogatory answers. As the trial court held, those interrogatory answers were not inconsistent. They did not object to the interrogatory answers at the time of trial, and the reason they didn't was because they weren't inconsistent. And again, the Supreme Court has ruled on this as well, and I think I read that to you earlier, but what they said is the jury's answers to the negligence and the causation interrogatories, both in favor of the defense, were not inconsistent with one another, nor were they inconsistent with the general verdict. So,
if they weren't inconsistent, how about confused?
I think, Your Honor, what the jury did was they took as the trial court said, they took an unambiguous instruction, read it incorrectly, and proceeded to answer the third interrogatory. But the first interrogatory, as the court knows, went to standard of care. The interrogatory was, do you find that plaintiffs have proven by a preponderance of the evidence that Children's Hospital was negligent? The answer was no. They could have stopped there and signed the verdict form. They went to the third interrogatory.
Well, actually, they were instructed to stop there, weren't they?
They were, but they went to the third interrogatory and answered that, which was on proximate causation. Do you find that the negligence of Children's Hospital, do you find that the plaintiffs have proven that the negligence of Children's Hospital approximately caused death? Their answer was no. So, again, consistent with what the Supreme Court has already said, those interrogatory answers were not inconsistent with one another. The jury verdict in this case was supported by the evidence, and that verdict should not be reversed as being against the manifest weight of the evidence. And the trial court did not abuse its discretion in denying plaintiff's motion for a new trial. In conclusion, Children's Hospital Medical Center of Akron would request that this court affirm the trial court's holding and uphold the jury verdict in this case. Thank you.
Since I had a clue it was coming, I'm going to start with Judge Carr's question. What can you do with the motion for new trial in reference to the fact that the Ohio Supreme Court determined that the jury instructions were wrong? I have been compelled to make a concession, and it hurts me to do so, but we did not preserve that argument in the motion for new trial. We cited manifest weight, and we cited the conflict in the jury interrogatories, but I didn't have the foresight to know what the Ohio Supreme Court was going to order, so I didn't raise it in my brief. So, in a matter of forthrightness, I've got to say that, so I can't really argue, except that I know there's Ninth District authority, I think written by Judge Dickinson, that says that any error of law is an abuse of discretion. And standard review for failure to grant a new trial is abuse of discretion. So if the court finds that there was an error of law, I don't know what you can do with that, but I can tell you that I did not raise that in my brief. We went down the path of causation a moment ago, talking about what the causation determination means. And throughout this case, the plaintiffs have argued that it was evidence of jury confusion, and the hospital has argued, no, it's not. It's an alternate ground to affirm the jury verdict. And that's flavored all through their brief. The Supreme Court held that it was neither. The Supreme Court held that it was mooted, that the causation determination was mooted by the finding of no negligence. That's at paragraph 42 of the Supreme Court's opinion. If we had been right, we would have won up there. If they had been right, we wouldn't be back here, because the court would have just put in a judgment at that level. So causation is really moot here. The question is whether or not the jury lost its way on the standard of care negligence issue. So with that being said, I think that's all I have for you, and I will await your decision. Thank you, Your Honors.
Thank you both for your presentations today. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website. Thank you both.
Thank you.